Any mention?
Your
Lordship,
Yes,
I'd like
yes.
to mention item number 18.
Number
18.
18. Namdonga.
Yes. Yes, Your
Namdong. Namdong E. Yes. Why?
Because Lord Senior is not
Not ready.
Not available.
Who's your senior?
the case consumed.
2 weeks, yes. 22 matter, yes. Fast, yes.
May it please, Your Lordship. Your Lordship, I beg to mention item number 22, Your Lordship. The conducting
20?
counsel. 22, Your Lordship. He's indisposed, Your Lordship, the conducting counsel.
Who?
Lordship,
Mr. A.G. Momin, Your Lordship.
Lordship, this matter has been posted for Lok Adalat. Referred
Oh?
to.
On the 9th?
Yes.
Lower on the 9th, yes. As a matter, number 22 mentioned been made that the matter has been posted to look on the 9th. According to this, thereafter. So, yes.
Hello, Your Lordship.
Yes. Yes.
Your Lordship, item number 31, Your Lordship. It will come after 2 weeks.
31?
Yes, Your Lordship.
Objection, Lordship. Lordship, I'll be filing the application for relieving that order, interim order.
For?
For that interim order, Lordship, to lift up the interim order.
For recall.
Yes, Lordship.
Say that.
Lordship, sorry, my word.
Lifting means what? Like a ban or a,
My apologies,
a
Lordship.
curfew? Yes. 2 weeks, yes.
All right.
Yes.
Your Lordship, I beg to make item number 19.
19. Who's for the petitioner? Who's for the petitioner?
Petition is the Elderly Junior, he was telling me.
No objection? 2 weeks, yes. On the request of Mr. Debmat, yes.
Your Lordship, I beg to mention item number 17.
17.
Your
On
Lordship,
behalf
the
of
conducting counsel is on leave.
Mr. Gautam's on leave?
Yes.
Okay, 17, 2 weeks, yes.
Okay.
Yes.
Your Lordship, I beg to mention number 38 and 39.
You are for?
For
Petitioner. What's the reason for adjournment?
The conducting counsel is out of station, Your Lordship.
38, 39?
No objection, Lordship.
As usual. 2 weeks, yes.
Obliged.
Obliged, Lordship.
Lordship,
Yes.
I beg to mention item number 25. Mr. Jay Shilla is having personal difficulties.
Who's for the other side? Right. Disconnected to other matters.
Yes, sir. Yes.
Why? You want to, these other matters, you're not appearing, the other matters, other councils are appearing. That is number
25.
26, 27, all linked together.
20, 21, 22, 23.
20? 20? Yes, Mr. Sai.
It's 20 to 21, 23 to 30,
20, 21, then 23
23 to 30,
to 30.
yes, and 33 to 37,
1 second. To 30 and 33 to 37.
37, and 41 and 42.
30, I'm appearing, my lord. I'm the petitioner, my lord. My lord, this third, my lord, I will have little objection, my lord. 2017, I have
Objection
retired.
to what?
My lord, if there's an adjournment, my lord, because 2017 I've retired. Likewise, many.
Adjournment made by the co-petitioners, not by them.
My lord, exactly, my lord. So
you object to the prayer for adjournment.
Well, because we'll have to. These are people all retired, my lord.
See, that is not a consideration whether they are retired or they are serving or they are someplace else. The thing is that as for today, difficulties of the council, that you are a council, other did it matter?
Don't ask for time, no?
I'm not asking because he's.
Lordship may take these up on Monday.
Monday.
Monday I will not be here. This coming Monday, 4th time not there. Milord, one submission, Milord. My matter might be separated, Milord. The others may be taken up because, Milord, in our item, Milord, our case is absolutely different from theirs. We are the association. We are not the individual retirees. That means retired persons.
Your item number?
33. 33, no? 33. And in our case, Milord, the case which we have made up is also primarily against the government, Milord, not against the MSB. Primarily.
Mr. Sai, is that correct?
Because our prayer is that the government has to provide.
In the last order, Lordship has recorded that the government may file a separate affidavit.
In item number 30. Who's appearing for the government? Item 30. 33,
Yes,
sorry.
in item number
33 is appearing for the state.
Lordship, Miss Jumat was.
Miss? With Ethunwa.
She's next for the column 3 Lordship.
We'll call up the matters. You stick around. Yes.
There's
Mention other
only
matters.
one other.
Yes.
In their matter, there is also a separate prayer against the MSEERC because their grievance is that the MSEERC is not including the retirement benefits as part of the tariff.
In item 33.
Yes, in item.
No, we'll call up the matters. You just wait for some time. Yes, we'll. Yes.
Supplementary list, item number 1.
Please, Your Lordship. This is a revision against an order passed with the learned Additional Deputy Commissioner.
Yes.
In brief, Your Lordship, from the beginning. The year 2008, a succession certificate was granted in my name.
In 2008.
8. And that is in respect of the debts and security left by my brothers and sisters. So that was granted to me in 2008. On the basis of that order, the debts and security as per the succession was granted. Thereafter, there were other debts and securities. I had filed for an extension. No, I am the brother of the deceased.
Oh, sorry, yes.
So there are other debts and securities which are not included in the original succession. So I had filed for an extension.
When did you file for extension?
Just a couple of months. And that was granted in the following year, 2009. Now, immediately after I got the succession in 2009, I forwarded this in the same manner that I've done earlier to the concerned department, which is the respondent. In this extension certificate, they had objected. They saying that they had to forward this matter to the higher authority. I waited for that matter to be resolved. There were numerous requests made by me, numerous correspondence since 2009. And finally, I had approached this Honorable Court by way of a writ. The writ petition is Writ Petition 191/2020, seeking just one simple
191
order. No, this is a writ petition registered as Writ Petition 191/2020.
And what order was
simple
passed
prayer,
there?
just a direction to the respondent to release as per the succession. Now, that application was again disposed of as there were other alternative remedy to approach the concerned court who had granted me the succession certificate. And accordingly, I have agreed to that. Liberty was granted to me. And in pursuance of that order, I had approached the concerned court. The concerned court has given ample opportunity to the respondent to file the show cause to the application I have seek to release. Just a simple prayer. After they failed to file show cause for more than a year, the court decided to grant my prayer. So court had directed the respondent to release those debts and security as per the succession certificate granted in 2009. A date was fixed. 2 months was given to them to release that money. A date was fixed after 2 months, and it was fixed for report on payment. Now, after the passing of that order, I had forwarded the order to the concerned department, the respondent, in original as per the request, and had complied to whatever they have required and asked me to wait. Now, on a date fixed after 2 months, instead of releasing the amount, they had filed a show cause. Now, I was surprised, why did they file show cause? On the basis of that show cause, the learned additional deputy commissioner.
So what did he say in the show cause?
Show cause, there were other reasons they have given, saying that there were other nominees and this and that, so many other reasons they have cited.
They never filed objections. I mean, did he get NOCs from the other nominees?
That was already been done at that point of time. It's been more than 14 years. If they were informed, they would have come to court.
Right.
Now,
so what happened?
Only on the basis of the show cause that they had filed, they responded.
Your prayer rejected?
Yes, it was
Where's
stopped.
That operative part?
The impugn order is right at the front.
Considering the fact of the parties filed show cause today on the opinion that debts and securities which are in custody and possession of authorities should not be released at the stage of preparing hearing show cause. So you come in interim stage only.
No, the prayer was already granted. Kindly come to page. Your Lordship, before you read
second last
that
paragraph of the impugn order.
Please kindly, Your Lordship, before you read this impugn order, kindly come to the previous order. That is at page. Please.
You agree with order 27.7, correct?
Yes. Please come to page 84, Your Lordship. This is the order where the court has allowed my prayer and directed the debts and security to be released as per the succession. It's clearly mentioned in this order itself that show cause he could not file. It failed.
Okay, heard by the anything to say? We dispose of next date for admission hearing listed.
My lord, we have filed this show cause. We have primarily on 2 counts, my lord, we are not able to release the money of the fixed deposit.
No, this is for admission hearing. Heard Mr. S. Marapan, the council petitioner issue notice. Dr. N. Mozika and the DSGI with so and so is present on behalf of the respondents. No further notice called for. You are paying for a general post office also?
All of them, my lord.
All of them. No votes called for. Stop considering the matter. This is same for the admission hearing after 2 weeks.
Flush.
Yes. You need the records?
Yes,
required, my lord.
I think so. It's required.
My lord, actually, what happened, my lord, they have to bring the original FD receipts, my lord.
No, that will hear. I mean, that doesn't matter. Records to be requisitioned from the lower court. Yes. Which is seen before the next date.
Pledge.
To reach this court before the next date. Yes.
Item number 2.
May I please, Your Lordship?
Yes.
My Lord, the matters with regards to the extension of the benefits of the judgment and order dated 31st August 2022, my Lord. Passed in writ petition WPC 62 of 2015, my Lord. My Lord, whereby the petitioners were reinstated in service with consequential benefits, my Lord. And my Lord, the petitioner also, the present petitioner also is in the same footing, my Lord.
Similarly situated. You're not part of the petitioners than the other petitions.
My Lord, in the first round of litigation, I was the petitioner, my Lord. But in the when it was restored back, my Lord, from the division bench, my Lord, I was not the petitioner, my Lord.
How?
My Lord, the former counsel of the petitioner, my Lord, was expired, my Lord, and therefore the petitioner has lost all sort of communication, my Lord.
But here what happened, my Lord? Justice Sen, my Lord, in a batch of around 89 petitions, my Lord, had dismissed their prayer, my Lord. Then only 17 odd of them, they went on appeal, my Lord. And then the division bench only sent back those matters qua the petitioners, my Lord. Now, as far as them, my Lord, there is a similar other matters pending also, my Lord. We have taken the plea that as far as them, there is a res judicata, my Lord.
What's your name?
My Lord, H. Yadav. H. Yadav, my Lord.
H. Yadav. How does H. Yadav issue notice to N-Mozika DSGI express an accept notice on behalf of all the respondents? Stop. You file affidavit. This is a matter after 3 weeks for affidavit is.
Item number 3.
Three and 4 are more or less identical matters.
Bring your petitioner here. Yes.
But lawsuit kindly takes up item number 4 first, my Lord. 3 and 4 are identical matters.
Yes, what is the matter about?
But here what happened, my Lord? The tented case, my Lord. The petitioner was
Tainted here, you're a tainted
My lord,
candidate.
I am tainted but not confirmed by the Chief Secretary, my lord.
Meaning?
My
But the
lord,
high level committee again. Second order representation.
My lord, what happened, my lord? As of now, my lord, after various orders, there are 3 categories of teachers, my lord. One are tainted and declared, confirmed tainted by the Chief Secretary, my lord. They are represented before the Chief
So
Secretary.
you have to be double tainted to be tainted. Is that your case?
My lord, as it stands now, my lord, there are double tainted, my lord.
Single tainted
Single
and
tainted and untainted, my lord.
untainted. Right.
Untainted were allowed to continue in the service, my lord.
Naturally.
Double tainted were permanently debarred from participating in future recruitment, my lord. I stand somewhere in the middle, my lord.
Single tainted.
Single tainted, my lord.
Means you're still open for employment.
My lord, that was the whole idea, my lord. I'll just point out that later, my lord, from the government itself, my lord. Well, page 77, my lord, so kindly see.
Yes.
My lord, this was a clarification from the Director of School Education, my lord, on 16 June 2020. If I come to second para, my lord, however, the tainted blemished candidates who have seek a representation to the Chief Secretary Government of Meghalaya for consideration as untainted candidate, but confirmed as tainted by the committee, he shall stand permanently debarred from seeking any government employment.
Yes.
My lord, the government itself, by clarification, says, my lord, as Lordship said, single tainted, my lord, single tainted will not be, only double tainted will be debarred, my lord. My lord, my case is, my lord, in the select list of 2009, my lord, I was at serial number 71.
Now were you in the appeal?
No, my lord.
Then you didn't file an appeal now because that I think gave a provision that you're going to approach the Chief Secretary who will re-examine that matter whether it will be double tainted or single tainted or untainted.
My lord.
Then
So I have not been confirmed by Chief Secretary as double tainted.
You never filed representation.
I filed a representation, my lord. What happened, my lord? My representation was rejected on the ground of delay, my lord. I've annexed that order. But on merit, there is no adjudication by the Chief Secretary that I am tainted, my lord. My lord, more importantly, my lord, I was at serial number 71 in that select list, my lord, where it is held that I am tainted, my lord. But I never got any appointment pursuant to that, my lord.
Who got?
When on the basis of which I was declared as tainted, my lord, I was never a beneficiary of that select list, my lord. I was never appointed pursuant to that.
Whatever the case may be, yes. Then what happened? But you
My lord, in the first place, I am declared tainted without appointment, my lord. If I was a beneficiary of that appointment.
Were you appointed on contractual service?
My lord, I was appointed on contractual service, but not pursuant to that advertisement, my lord.
Were you not a stopgap kind of arrangement?
No, my lord. I was not even a stopgap. After I came serial number 71, my lord, because there was no vacancy for assemblies.
So what you're submitting that you come in the fine line, that you don't come anywhere. Your case is still
My lord, I am before Lordship on 2 counts, my lord. Number 1, that though I have been declared as tainted, but I was never given appointment, even though my name was there in the selection.
Never took advantage of being tainted.
I was never given any advantage, my lord. Secondly, my lord, I've annexed the list of CBI, my lord. There is no recommendation by any MLA, MP or any public representative in my favor, my lord. I can point that out, my lord. How it happened, it appears, my lord, in my case, in the petition item number 4, because I had experience of 2 years, my lord. And it appears that initially when the scrutiny was done,
weightage was given to that.
Some white ink was put to correct that genuine mistake, my lord.
Anyway, Mr. Shula,
my lord, my only difficulty, my lord, the advertisement is closing on 31st August, my lord. My lord,
see if you are only single tainted, then you just clarified, but only of writ appeal are allowed to submit applications. You were not party to writ appeal on 52 as per this annexure 10 that you've shown. Correct? Then where is the scope for you to apply?
My lord, but my application has not been rejected on that ground, my lord. My application has been rejected, my lord, only on the ground that I submitted it belated, my lord.
Where is that rejection?
My lord.
No application for representation, you mean?
Yes,
or application for the post.
No, my lord, representation to the Chief Secretary, my lord, was rejected only on the ground.
No. Why? What is the urgency now? What are you seeking by the?
My lord, why have come, my lord?
There are two advertisements now, my lord, in the offering, where the closing dates are approaching, my lord.
Where is that?
Page 87, my lord.
That is why you have come.
My lord. My lord, I have cleared MTAT, my lord. I have cleared DLAD. Whatever qualifications are required, I am fully qualified, my lord. Page 87, my lord. This is the advertisement in respect to Ampati. My lord, the last date is at page 88, your lordship will see 31st August in the first paragraph itself.
The why you've come so late?
My lord, submitted representation, my lord, that I am single tenant. My lord, what I pray, my lord, at this stage, at least they can allow me to submit my application, my lord, and then subject to outcome of the writ petition, my lord, they can file an affidavit.
Will open the door to many single tenanted candidates who come now. If your representation is considered rejected by filing beyond a period,
because my case,
that's the deal. It might be technical, but it's a rejection.
My case, my lord, I was never a beneficiary of being tenanted.
That doesn't matter.
My lord,
it's just that.
My lord,
that you're a victim of circumstances.
My lord, in the other case, my lord, who is the wife of the petitioner, my lord, there we don't know whether some writing is there, but there is no finding whether my marks were increased or decreased, my lord. When there is no recommendation by any MLA, why and for what reason the authorities were tampering with my marks, my lord?
Yes, Mr. Shulai, what do you have to say?
May it please your lordship. Lordship, can you see, your lordship, the admitted fact is that, your lordship, both the writ petitioners, your lordship, they took part in the selection of 2008, your lordship. So there was a CBI inquiry, your lordship, and they have been found tainted. So, some people, they have come and filed, your lordship, a writ petition and then carried out in writ appeal.
Yes, no, we all know about that. This is a very famous case here. Yes, what happened?
Your lordship, can you come to page 7 of the writ petition at 2, your lordship. Page 7 at 2.
7 at 2, yes.
Lordship, for the candidate, lordship is with me?
Yes, yes.
May I read it, your lordship?
Yes.
For the candidate who have been found tainted, blemish in the CBI report and or H report for Shillong, Sadar, Joy, Amnaram, Tura, it is provided that any such candidate, if so desire, may make a representation within 30 days from today. That means from the date of 2/11/2017, your lordship. To the Chief Secretary to the Government of Meghalaya for consideration as untainted candidate. The Chief Secretary shall get such representation examined by a 3-member committee comprising of himself and 1 member from the State Civil Services having unblemished service record and of impeccable integrity, and 1 independent member from any central or state educational institution or university. The said committee shall take action on such a representative within 60 days of making. Lordship, can you see? Within 60 days, everybody has to file the said representation. And if the committee would accept the representation and treat the candidate as untainted, she shall be entitled to the right of participation in the fresh selection process at par with other candidates. It is, however, made clear that if the committee would confirm the tainted character of any such candidate, he shall stand permanently debarred from seeking any government employment and shall also be liable to so and so, your lordship. So the fact remains, your lordship.
You're from which center? You're from Ampati?
That agree, my lord.
Lordship, can you come to page 61?
Now I want to apply for Ampati and other subdivisions also, my lord.
Lordship, can you come to page 61? That is the letter dated 14 March 2018. And I may read, your lordship. As per the recommendation dated of the scope committee headed by the Chief Secretary of the Government of Meghalaya containing report so and so, you are hereby informed that you are representing in the 21st.
Why you didn't file within time?
In the education department stand rejected. Your lordship, the representative was rejected in the year 2018, your lordship. Where was he, your lordship?
My lord,
in 2018,
my lord, Mr. Chulai will appreciate my position, my lord. My lord, I am not even a beneficiary. I was never appointed pursuant to that, my lord. If I was a beneficiary and I was serving in any school, my lord, because of that, and if there was a case of termination, I would have been extra cautious, my lord. But here is a case, I am not a beneficiary. I have forgotten about the selection process, my lord.
Lordship,
so you're not really concerned about your future employment prospects also?
My lord, till then there was nothing that only those, my lord, the division bench order clearly says, my lord, Mr. Chula is read out, only if they confirmed by the committee of Chief Secretary, my lord. Then
you must be rejected because filed beyond time. So that ends there.
But the rejection is not on merit, my lord.
Doesn't matter. You want a manibus from here to say the exam representation before the 31st, and if you're not tainted, then the application can be made.
My lord, my lord, may I read once again, my lord, the only one sentence, my lord, in this order at page 7, my lord.
Page 7.
It's page 7. Page 7. I've quoted the order of the division bench.
Yes, we've seen that.
It is, however, made clear that if the committee would confirm the tainted teacher of any such candidate, he shall stand permanently. So only if the committee confirmed, my lord, I would be permanently debarred.
But your rejection, but your representation has been rejected because it's beyond time. You have not complied with the order of the court. That means you deserve no consideration. That's it. We can't show this kind of latitude to one person and the other persons, the other similarly situated persons.
My lord, it will not open up for floodgate because all other tainted, my lord, tainting coupled with appointment, my lord, they stand in altogether different footing, my lord.
You have to take your chances. You have to forget about selection. Maybe the next selection comes.
But I'm permanently debarred, my lord.
No. We'll keep your reputation alive.
My lord, what I was praying, if subject to outcome, my lord, if my candidature is considered, supposing that I fail in the writ petition,
we'll just have a cascading effect. It's not the first case.
My lord, in my humble submission, will not have cascading effect because the cases like mine, my lord, are very few and far between.
How many?
Those who are tainted and not appointed, my lord.
There are three other matters, I think, which has come before this bench on the same thing. Just for renewal of contract.
Those were renewal of contractual
exactly. Now they'll come for application. Same thing. They're saying the renew contract. We were single tainted only.
My lord, their case is altogether different because even I was a contractual teacher, my lord.
You're a contractual teacher also.
I was a contractual teacher, but that appointment as contractual teacher is not pursuant to that particular selection process, my lord.
Is disposed of?
That one disposed of.
Disposed of.
Last week only, your lordship.
Sorry, Rahul.
My lord, kindly see, my lord, the CBI list, my lord, at page 92. For a moment, my lord, kindly, my lord, page 92. My lord.
You've extinguished your own right by not finding representation within time.
But, my lord, my name is at serial number 54, my lord.
Yes, you have not.
Yes.
Let me.
Yes. Tempered, yes.
Selected, yes.
Tempered, yes.
Tempered, yes. Whether approached any public representative and recommended? No, my lord.
Doesn't matter. Yes, Dr. N. Mozika issue notice. Mr. N.D. Shulai with so-and-so, Learned AAG with so-and-so, accept notice on behalf of all the respondents. Stop.
My lord, may I one more sentence, my lord, may I just point out, my lord, from the order provided by the Justice Maheshwari at that point of time, my lord, at para 7 again, my lord, page 7, my lord.
Yes.
It says, para 2, I'll read from beginning, my lord.
Yes.
For the candidates who have been found tainted, blemished in the CBI report or HSLC report for Shillong Sadar, Joai, Amlaram, so and so, it is provided that any such candidate, if he so desires, may make a representation within 30 days from today to the Chief Secretary to the Government of Meghalaya for consideration as untainted candidate.
Exactly.
My lord,
you may make 30 days for you didn't bother. He said, I'm tainted.
But
you
my lord,
you want to be considered untainted.
But my lord, then we go to the last sentence, my lord. It says, if confirmed as tainted by the committee, then I will be permanently debarred, my lord.
We can't have this kind of conditional kind of orders. Yes, sir. I thought, no. Sorry. Dr. M. Mozika, Senior Counsel with the petitioner, has raised strong arguments with regard to the eligibility of the petitioner to apply for fresh selection in pursuant to the advertisements which have been annexed at the annexure.
The advertisement, page 87 and 89.
At 87 and 89 of the writ petition, stop. the main ground taken by the writ petitioner is that though found tainted by the inquiry by the CBI, the representation which was filed to the Chief Secretary and committee thereafter was not addressed, as the same was not considered due to the delay in filing the same. He prays that the writ petition be at least allowed to apply and the results of any such section be subject to the writ petition. Next parameter, Mr. Andy Shulailer, AAG, has refuted the arguments by submitting that the rights of the writ petitioners to be extinguished as much as the representation was rejected as far back as 2018. Considering the facts of the case and the materials on record, at this stage, no interim orders are called for. This matter after 4 weeks for affidavits of any yes.
Apply, Your Lordship. Item 3 stand on a different footing, Your Lordship.
Yes, item 3
stand on a different footing, Your Lordship. These are double tainted, Your Lordship.
3.
It's identical matter, the husband and wife. The husband and wife.
Same.
No, Your Lordship. I can see.
Okay, we pass on orders in item number 3. Dr. N. Muzika issue notice so and so, exemptions on behalf so and so. Yes, a matter of 4 weeks. Page 83, anything. Another
Lordship.
Judicial time, please.
Lordship.
Main list, item number
I
1.
apply, Your Lordship.
In this matter, settlement talks are going on, my lord.
We will not go by that anymore.
Absolutely correct.
No adjournment, yes. What settlement talks are going on?
My lord, they were called on 28th, my lord.
We made it very clear to them that these settlement talks would happen on the site, but we would not be taking any adjournments. We would not entertain any adjournments from the petitioners.
My lord,
And that's exactly what they do, deliberately.
Matter may be come up after some time, my lord, at the end of the vote.
Yes, after 10 minutes.
Both the matters connected.
Item number 3.
Same order thing that will cover.
In this case, I have to file my affidavit, and you took.
Respondent will be relying on the affidavit as filed by respondent 9 of initial.
You're filing today?
So you should do it sometime,
Enough of time. This is a 21 matter.
It is due to personal difficulties, I was not in a position to prepare. And by weeks.
By?
1 week.
Mr. Dharma submits that due to personal difficulty, the affidavit on correspondent 9 could not be filed. The praise may allow 1 week's time to file the same stop. As MS Restroom Thao for respondent number 8 submits that submits that the affidavit file by respondent will be relied upon by this respondent also. What about state file? You already filed. You are appearing for number 10. Who's number 10? No, who's number 10? What respondent? What's who will know what's MIG? Yes? You're for GHDC? Yes, MSCB Savian for respondent number 10 submits that no affidavit forthcoming their side. List the matter after 1 week for affidavits by respondent number 9 is.
4?
Yes.
4. And for the respondent was 6.
I can find. Yes, 5 and 6. You're not 5.
In this matter as well, we will be relying on the affidavit of respondent 6.
Same thing. You won't file affidavit. Here for 7. See, 7 is 7. They're not for 6. And ruled how for 5. It's already filed. You won't record anything if you already filed it.
5.
Order tang change for number. Yes, where's MS NG Shila?
Lordship, your daughter's not well, Lordship.
No, but has any resolution come about?
Lordship, I've seen last order, Lordship, as per my instructions, we haven't received the complete instructions as yet.
What are the instructions?
Lordship, as per my instructions on the 3rd of August, there was a joint inspection conducted. But thereafter that, they're still waiting from the government side for any information.
But I mean, coming to personal knowledge, I saw the minister making a statement that they've already apportioned land to be given to you.
Yes, Your Lordship, but nothing in the formal intimation has come to us, Your Lordship. Any
Just political promise.
Yes, Your Lordship, as of now.
What's happened to NG Shila?
Lordship, as I stated, her daughter's not well. Her son, Lordship.
Because last time she said she received preliminary instructions indicated that a plot of land measuring 13,500 square feet has been identified for liquidation of the
Lordship, as per order. But then the complete instructions are still being awaited, Lordship.
May Chairman please that matter be adjourned for today in view of the fact that due to the absence of MS NG Shilla due to personal difficulty, is by order dated 9/8/2023. This court had noted the preliminary instructions which had been apprised by the senior government advocate who had received preliminary instructions with regard to the identification of a plot of land measuring 13,500 square feet for allotment to the petitioner. The state is to come up with specific instructions on the next date. List on. You take a date, Lordship.
After 2 weeks.
Because otherwise we'll pass orders.
Lordship.
Yes.
Hello.
Item number 6.
In item number 6, Lordship, we have received the affidavit filed by the respondent number 4. We need some time to deal with the affidavit, Lordship.
Deal with the affidavit?
Lordship.
Why was there to deal with it?
Sometime they have raised certain issues, Lordship, which we have to deal with.
Yesterday only?
No, my lord. Last one. 14, my lord.
1 week time, Lordship, may be granted, Lordship. And
Mr. Chanda, for we place the matter with him after 1 week. It is allowed. You're not filing affidavit.
Item number 7.
Lordship, this is that election petition, Lordship.
For withdrawal?
No, Lordship. Here, Lordship, we are seeking for some time, Lordship, to deal with the 711 file by the respondent number 1.
How much time will you ask?
Some time.
Forever. You're the election petitioner, correct?
Lordship.
Very good. That is an application for seeking additional time to file objections to the application under Order 711 CPC for rejection of the election petition. As per 2 weeks time for them is granted just thereafter.
Yeah. 8.
Please, Your Lordship. Your Lordship, we filed our affidavit yesterday, Your Lordship.
So you've complied with the order?
No, Your Lordship.
Why?
Yeah, the matter, Your Lordship. Your Lordship, here the matter, the service book of the petitioner had to be reconstructed, Your Lordship. Because we are saying that we had submitted it to the Director of Local Funds. However, the Director of Local Funds is saying that they have not received the service books and connected papers. So, Your Lordship, as per my instruction this morning, Your Lordship, the reconstruction is about to be complete.
So, what do you do?
My Lord, because there are lots of internal communication since 2019, Lordship, with regard to the service book, Lordship. Let it be pending, Lordship. Let it be pending, Lordship.
After it's been filed, we have respondents.
Otherwise, again, I have to come.
After 3 weeks, yes.
Right, Your Lordship.
Item number 9.
For the orders, yes.
9.
For respondent number 3, I'm filing my affidavit in the course of the day.
3 and 4? Why, Mr. Kriam? You're doing some other business. You're not regular in court and not filing affidavits.
No, that's only one week.
Then?
Translation.
Mr. R.K. Salim for respondent number 3, you're not filing. Submits that affidavit has since been filed. Mr. Bikrian, however, prays for 1 week further time in view of translations that have to be completed. The praise allowed this the matter after 2 weeks. Yes.
10.
This is your lordship. Lordship, in this matter we need some time, your lordship. Instruction has been received, your lordship. 2 weeks time can it be permitted, your lordship?
1 second. Seven?
Your Lordship, I'm appearing for respondent number
Yes,
7.
yes.
And Your Lordship, we'll be filing our affidavit during the course of the day.
For the day. What about the other one to bring on record certain facts?
It was not me, my lord, by the state.
No, it's MS Panjam. You're not aware?
No, my lord, I was not aware.
What's the matter about?
This is regarding export of limestone to Bangladesh, my lord.
Yes, MS Ekhashi on behalf of number 7. Here, file.
Lordship, we need some more time, your lordship.
1 week's time only.
Let it be 2 weeks, your lordship.
Mr. N.D. Shulailan AAG on behalf of 1 to 6. Please that we have 2 weeks time to file affidavit. Stop. Mr. MS Ekhashi on behalf of the respondent of 7 submits that I will find the course of the day. On this matter after 1 week or 2 weeks.
2 weeks. Apply, your lords.
11.
Yes.
May I please, Lordship? Lordship, I pray for 3 weeks' time to file affidavit in this matter.
What number 4, sir?
I'm entering my evidence.
Very good. Mr. S.A. Sheikh today has entered appearance on behalf of respondent number 4. So such a service complete. How much time you require affidavit? MSP Agarwal for 1, 2, 3 and Mr. S.A. Sheikh for 4. Prayer allowed 3 weeks time to file affidavit. Prayers allowed after 3 weeks. Yes?
Status quo order may be maintained, your lordship.
Yes, status quo. If this was passed earlier?
No, your lordship. Today's consideration for the interim.
Yes.
Today's date fixed for consideration.
What interim? Do you have any objection to the interim prayer?
My lord, he's saying that his post for the his approval for the post of headmistress has not been considered and rejected.
Has been rejected or has not been considered?
Rejected on the ground that she does not possess the B.Ed degree, which is mandatory, my lord.
Yes, you are serving headmistress now.
Assistant headmistress, there is a promotional post, your lordship. I have joined in 1991.
For what? What do you want status quo?
It's just because I am discharging my duties as
assistant headmaster.
Yes, your lordship. Since as the headmistress, since
let them file the affidavit just after 2 weeks.
About 3 weeks.
Take 2 weeks enough.
12.
Your Lordship, we have taken steps for respondent number 3, 4 and 5.
Number?
We have
Speak a little louder.
We have taken steps for respondent 3, 4 and 5.
You're appearing for them?
No, my lord. 1 and 2.
No. Oh, he's with you.
We together.
The office note indicates that service, the AD card of respondent 3, 4 and 5 is not yet received. So, what do you want to do? You obtain status or you'll wait for service report? Yes, stop. Next paragraph, Mr. S. Jindal. How much time?
3 weeks.
Says that he will allow further 3 weeks time to file affidavit on behalf of 1 and 2. So this is matter after 3 weeks for affidavit by 1 and 2 and for service report on the remaining respondents. Yes.
13.
Please, Lordship. Lordship, all the self-notice to the all respondent, Lordship.
They all received?
I think the respondent 7 have already filed the affidavit.
5 and 6 not received. 7 is filed.
I've already filed the they have already filed the affidavit and I've already received, Your Lordship.
You filed after the service?
No, Your Lordship.
the affidavit in a
7?
person.
No, that's all right. It's recorded here. Who are
So in
you?
the meantime-
7?
I'm the principal. Respondent number 7.
Who's respondent number 7?
Principal of Finance.
Principal of school.
Yes, sir.
The present principal or the past principal?
The present principal.
And you appearing for?
I'm for the respondent number 5, Your Honor, Nicholas Kapunga.
5 is?
Nicholas
Private respondent.
Private respondent.
What is your name?
Nicholas Kapunga.
Your name?
P. Mauri.
P. Marwin.
Mauri.
Mauri. You are for 7. Who's for 6? Now appear for 6.
Yes, may I be allowed to file an affidavit of service because of all the serve notice since the 16th of this month, Your Lordship.
Anyway, what about
Your Lordship, I pray for time on behalf of respondents 1 to 4.
7? You already filed affidavit. Very good.
Even
Yes.
we can for.
Yes? Okay. Just thought me. What's your name? Sorry? No, the other one. Not B. Marwin. Archival MS B. Marwin. Learned counsel under the parents' behalf of subject number 5. Archival has as appearance on behalf of number 7 and has already filed affidavit. Stop. Notice on respondent number 6. Service report is yet to be received. Stop. Next paragraph. MS said inquiry pays for
2 weeks time,
for
Your
the 2
Lordship.
weeks time to file affidavit. Some praise made by counsel for respondent number 5. Stop. You want to file service affidavit?
Yes, Your Lordship. In the meantime, also, I may be allowed to file a rejoinder to the affidavit filed.
Yes, for respondent number. Sir, please, on behalf of respondent number 5, stop. Mr. Khanongbak for the petitioner. Please be allowed to obtain status and file a service affidavit with respect to service of notice on respondent number 6. According to this matter, after 2 weeks for affidavits by respondents 1 to 4 and 5, and for rejoinder, or 5, for service affidavit and rejoinder by the petitioner. This accordingly and so and so.
Obliged, Your Lordship.
14.
Lordship, in both the matter 13 and 14, Lordship, 14, 15, we need some more time, Your Lordship.
What's the matter about?
This is a
promotion matter.
Promotion, Your Lordship.
Yes. Mr. Anishwaran AG prays for the further 2 weeks time.
Let it be 3 weeks, Your Lordship.
3 weeks time to file affidavit. This thereafter and so and so.
Obliged, Your Lordship.
All have been served. Or you appearing for all?
For all. For all the respondents, Your Lordship.
Muda, I thought a separate.
No, Your Lordship, this is from Urban Affairs, Your Lordship.
Department.
Urban Affairs Department. Obliged, Your Lordship.
Second call, item number 1.
You got that letter? Type my order, huh?
Milords, I think a submission was made on my behalf of my learned friend that we were called for a meeting on Monday. I think my learned friend was disputing it on behalf of the MTC. It's very unfortunate that this kind of statement is made in court.
Where my senior friend is not informed. I have not disputed that. The meeting was held, but we had made it very categorical that we will not entertain any request for adjournment. We would like the matter to be heard in its usual course. That's all.
I was not seeking an adjournment.
Notwithstanding settlement talk, what happened settlement talk?
They have offered us a certain portion, Milords, which in principle we have agreed. They've called us at 5 o'clock today. That is my instructions.
But that maybe, but we understand that this will take a very long time. That does not mean that the PP proceedings should not go on. Because we made this attempt earlier this year. And that did not.
We take up which matter first? Give the other matter first, where they have.
Because I wanted to produce this letter by which we were called.
Yes.
They're just taking a print of it. Now bear with me for it.
You have filed a joint affidavit?
File minutes. This is that matter where your lordships, 2 orders were present by the Deputy Commissioner on 2 different dates. Arkin, you want to pick up the note? Stop.
You can start. You can start.
Okay. Where's the counter after it? You filed the rejoinder? Yeah, we have a list of dates. Have you prepared a list of dates? No. Courtmaster.
Yes, yes.
Well, its individual notices were given to all the tenants.
Yes.
And well, we appeared before the authorities on the 28th of August 2023 at 3 p.m. Well, a proposal was given. Well, the road opposite, well, it's the petrol pump, the Jail Road petrol pump, which comes towards Pegasus Hotel, connecting from behind. That particular corner, around 3,000 square feet. What was offered was 3,000 square feet over there could be given to rehabilitate the tenants. Because the only point on which the settlement talks had failed on
That's
the last
prime property.
So they are willing to rehabilitate us when the building is constructed, within the premises. During the pendency of the construction, or while the construction is going on, there was a talk saying that we would give you that you could, so that there's continuity, you could continue to have.
The way he said it's at 5 o'clock and today.
Well, that has been informed to us verbally, That is a follow-up.
No, I'm not aware of that.
We'll take this matter up tomorrow. Then.
We had made it very clear to them that while these settlement talks are going on, we don't know how long this will take and whether it will fructify at all. But we would not stall the proceedings before this.
We'll take up tomorrow. Then.
That was a clear understanding with the parties.
No, I have no difficulty in starting with this matter right now.
Senior counsel at the bar has produced a communication dated, with a notice dated 24 August 2023, whereby the respondents had announced that the meeting was to be held on 28th 2023. It is submitted that the meeting was attended by the petitioners, and the meeting is is to be held again today at 5 with regard to the offer made by the respondents. Stop. Those strong objections have been made to any adjournment passed by the though strong objection has been raised to any adjournment prayer by the counsel for the respondents. In view of this development, this is matter tomorrow to enable the parties to inform the court as to any development. Give her a chance. It's better that quietus comes outside the court than,
Lordship, because this matter has been lingering on for 2 years, on and off, we were here before the court.
Both of you are losers, anyway.
Absolutely, my lords. Which is why...
I also stand in the equal footing.
Of course.
Everybody, all the tenants were called. As a matter of fact, my learned friend, I'm informed, was very much present for the meeting.
He's a tenant also?
No, I'm married, but I was there in different capacity.
As a counsel, not as a tenant.
I'm a little surprised. On the one hand, they're calling for a meeting, and on the other hand...
Yeah, I haven't heard of a carrot and stick policy.
Exactly.
So, that's the thing.
With a camouflage, it's a carrot with a camouflage of a stick. Camouflage.
Yes.
Hearing, supplementary list, item number 5.
Hearing, no? Mr. Kurihi, we just call it the connected matters today regarding the MECL.
Main list.
All of you are appearing that matter.
Item 20, connected matters.
Mr. Who was seeking adjournment on behalf of what matter was that?
Mr.
25, my lord.
Mr.
Yobin was saying something.
My lord, 25, my lord. Job Sheila is not available today.
Who?
Job Sheila, my lord. J. Sheila, my lord.
Oh, he was mentioning.
Yes,
yeah.
yes.
Okay, well and good.
25, my lord. That is item number 25.
Just 1 second.
Petitioner.
25, okay. Shinti, okay. The others are all present.
My lord, yes, I'm for 20, 21, 23, 24, 26.
Well, for 34, 35, and 36.
I am for 37.
Okay.
Item number 33, my lord.
Yes, we'll take it out first. You want to delink it.
Dealing is not, my only point is that because the matter,
33
if the matter comes up on Monday, I will not be there. If it's some other day, I am taken up because I don't know. Next Friday.
Okay.
Because Monday, my lord, I have already planned.
No, of course. You have the liberty, we don't. Yeah.
Anyway, the MECL has come up with a proposal, but we as an association, we are not in a position to concede to that proposal because our case is different. Our case is against the government. Now, whether this proposal of MECL that will be acceptable to the other petitioners, if it's acceptable, we don't have a problem with that. But we.
No, but do you want to delink it or not?
Yes, because our case
Yes,
is
sir.
different from MECL's. Our case is basically against the government.
39-2023. Stop. 39-2023. This matter has been taken up together with other connected writ applications in view of the fact that it relates to the terminal benefits of the employees of the Meghalaya Energy Corporation Limited. Stop. However, when these matters have been called out today for hearing, Mr. S. Chakravarti, Learned Senior Counsel, submits that WPC number 39-23 stands on a different footing inasmuch as the substantial relief claims against the state respondents, not against MECL, apart from other supplementary prayers have made therein. Stop. This submission is not you not objected to by the Learned Counsel for the Respondent Corporation. Stop. In this view, the matter WC 39-2023 shall stand delinked from the other connected matters and be listed independently. Stop.
If you come on the 8th,
List the matter on the 8th is for hearing.
Right.
Yes.
My lord,
Not other matters here.
My lord, all other matters are connecting to the same retirement benefit.
So,
my lord,
when should we have it? Mr. Sheila is the leading counsel for all the cases.
Only for this item.
Only item 25.
This matter is the lead matter.
Now, my lord, only one small prayer, my lord. Similar matter has already been disposed of by this court, giving them, giving the departments, corporation some time, 3 months, 4 months, my lord, to make the payment. So even if these matters, my lord, it has been quite long time, my lord.
No, which order is that? Is there an order, Mr. Sai?
Yes, my lord.
Yes.
Lordship, there was an order that had been passed in the case of Evermore Masar.
Yes.
Where Lordship, yes, in that a contempt had also been filed and that contempt was thereafter disposed of in view of
my lord. Only small prayer, my lord, if...
So this one is sanction letters already there. That is why...
All cases, my lord, sanction letters.
In all cases, sanction letters are here.
All, my lord.
Even in my case, there's a sanction.
Only, my lord, if they are given little bit more time also, my lord, we have no objection as to that effect. But at least within time bound period, my lord, they should clear the amount, my lord. Petitioners, they are retired.
I may just respectfully point out one thing. Some of these matters, Lordship, have come up before the Lok Adalat. in the Lok Adalat, the statement has already been made on behalf of the corporation that at least 50% of the leave encashment benefits have been discharged.
Where's that?
We have already filed an affidavit to this effect.
Not in our
Okay.
case.
My lord, one affidavit for
We
all the
filed
matters
one
which is
affidavit,
committed.
and para 3 of that affidavit we have
We have
detailed
given you the
this
copy.
fact. So therefore, an assurance of time-bound payment of leave encashment benefits has already been made and recorded in an order of the Lok Adalat.
Remaining benefits.
So therefore,
Who was appearing? Who appeared? Lok Adalat? You appeared.
Can you come to order dated 19/5/2023?
In WPC number?
WPC number 47/2023.
I don't know.
Just give me one. What is it now?
Yes.
We have just stated that the remaining 50% of the LEB as well as the DCRG will be within 6 months. Now, in the affidavit dated July 2023,
You see otherwise.
we have stated that
2 years.
Period of 2 years.
No, maybe he misheard when they gave instructions. Instead of 2 years, had 6 months.
Just to cut short the entire matter, my lord, if my lord will...
No, that is why we had asked for a concrete proposal. How are you going to settle all your dues? That is why we kept asking for.
My lord has already given order on the last occasion. They have complied with the order, and we believe, my lord, if my lord passes order,
Evermore must have complied.
Already, my lord.
They gave the entire 14 lakhs.
Entire only small bit amount was, my lord, left. I think that will also be cleared.
There are other 3 matters, my lord. Even the direction has been given. But we have an interim. We've been put it through petition of the discharge has been cleared now.
Just to avoid contempt, they've done that. How many petitions are here altogether?
Around 15 to 16.
Around 15, my lord, if I'm not wrong.
Okay, we'll list this matter on Monday. Tuesday is what date? We'll finish them off. You tell Mr. Chilla to be here.
16.
Yes, sir.
Tuesday.
WPC number appearing? Item number? Sorry, 25.
25.
Yes, sir. So prayer has been made on behalf of Mr. J. Chilla, who's appearing one of the connected matters, namely item 25, some accommodation stuff. Accordingly, this is matter on Tuesday. Yes.
Obligement.
Here, take this back. Yes, Mr. Puri.
Lord, this is the case.
Anything remains here? What is that?
We have filed an argument, and Lord, even if there is a chances of settlement, because the Lok Adalat is sitting on 9th, if the parties are willing, they can.
Shaking his head very vigorously, I guess.
Because ultimately, I have only one house. There is only a house I am residing there. If they come and take away the house, I'll be on the street only. I don't have any other place to
That's
go.
only why this matter kept pending so long. But the law is a law.
Law is a law, yes. But even then, the decree was passed when the plaintiff already died, and it's not substituted. So the decree, in fact,
the substitution actually was filed,
but it was filed
taken up by the
much later. Much later.
My lord,
It was filed on 2017 only.
That particular aspect has already been heard. We have shown that we have filed and clarification also.
The records are here.
And after
Any further submissions you want to make? I don't remember the matter. I will go through the file.
Yes,
myself.
yes, we have already filed a written
I'll go through the file
My
myself.
lord, this honorable court was pleased to ask us to file the list
Sequence of events.
I've
I
already
also
filed.
filed.
Everything
Okay.
is on the.
It's fine.
I've already filed before.
Right, then we will reserve for judgment. Yes, as a party submit a sequence of events as directed by the court have been filed. This is matter for the hearings concluded and judgment reserved. Though it was last heard on this, okay. Before that was on 4th of August, nobody appeared. 14th, it was last heard on 27/6. Anyway, yes.
Main list, item 16.
Yes.
Bishop, this is the appeal against the order dated 6/8/2000.
6/8. How long did it take? Just couldn't have time today because of some other engagement.
Your Lordship, I will take 10-15 minutes, Your Lord. Very short.
You take 10 minutes.
It depends on him. I have to reply or whatever.
Good answer. Any urgency?
There is some urgency, Your
We'll
Lordship.
take it after 1 week. This one, yes. This matter after 1 week, yes.
Obliged.
22. Sorry. 32.
Lordship.
Yes. How long will it take, Mr. Khera?
It'll take some time.
Take some time. Because the court can't sit after 1:15. It's no problem.
Lordship, all pleadings are exchanged. It's for final argument.
When can he have it? It's very hard to. He's not available many days.
Lordship, because my grievance here is very limited.
Any interim orders operating?
No interim orders were passed, Lordship. They have already debited around 19 lakh some odd thousand from our accounts. All we want is them to give us the details, which we have been asking from them since they had served us the first notice in 2021. That how have you come to this calculation?
They have not given that.
Lordship, they have given us one sheet which does not explain how they have come, because they have asked us to pay this sum of money for a period between 1993 and 2006, for which they sent us a summon in the year 2021.
Okay.
And what they justified is that because of an audit we came to know. Now, audit
amounts had escaped.
That this is the amount which exists along with interest. All we said is that in 2006.
So they just deducted from your account, or what was
they
it?
deducted from our accounts.
Okay.
We had filed, by the time we came with the this writ petition and a miss case, the amount had already been deducted.
Okay, we'll have it after 1 week. It's a 23 matter. We'll have after, there's no urgency, right?
There's no urgency.
Yes, after 2 weeks, yes. But you be present on the next date.
40.
Obliged, Lordship.
Okay.
Yes.
This matter is basically we are challenging the cancellation of the tender process.
Yes.
Because no ground was mentioned in the cancellation order, and the respondents now have come up with a response stating that there were only 2 bidders and only one of the bidders had qualified the technical bid. So for the financial bid only one person remains, one of the bidders remain. But my lord, my submission is that the entire tender project was governed by the 2020 regulations of the bank from where they had taken loan, and according to the procurement regulations of 2020, it says that competition will be, means it lays down the guidelines on the basis of which competition is there or is not there, that needs to be determined. So as per the 2020 procurement regulations, my lord, this cancellation is illegal. Cancellation of tender process.
How they're the owner of the project? How can you say
My
cancellation
lord,
is illegal?
I can show the
Yes.
notification. If your lordship only takes up the affidavit in reply, that will also suffice.
Their affidavit.
My affidavit in reply, rejoinder.
Let's have the. What is the case about? What tender for what amount?
This tender was for rehabilitation and improvement of a dam.
Okay.
Mintudu Dam.
Sure.
My lord, if I may take your lordship to page number 16.
Of your reply affidavit.
Petition.
Okay, writ petition.
page number 16.
Yes.
Dam Rehabilitation and Improvement Project. My lord, if your lordship kindly sees paragraph 2.
Yes.
Bidding will be conducted through national open competitive procurement using request for bids as specified in the World Bank's procurement regulations for IPF borrowers, November 2020.
Okay.
Now, my lord, if I may take your lordship to the 2020 regulations. (2020 regulations), page number 566.
Five 566,
my lord. Clause 5.58. Clause 5.58.
Okay. Goods, works, and non-consulting. Okay.
And non-consulting services, okay, which falls under rejection of bids or proposals.
Yes.
Rejection of all bids or proposals is justified for contract subject to prior review with the bank's no objection when effective competition is lacking. Secondly, all bids or proposals are not substantially responsive to the requirements of the procurement documents. Thirdly, the bids or proposals prices are substantially higher than the updated cost estimate or available budget, or none of the technical proposals meets the minimum technical qualifying score. Now, my lord, their stand is lack of competition. On lack of competition, if your lordship kindly takes clause 5.59.
Yes.
5.59, my lord.
Yes.
Lack of competition shall not be determined solely on the basis of the number of bidders or proposers. Even when only one bid or proposal is submitted, the process may be considered valid if, my lord, here there are three qualifications. Firstly, the procurement was satisfactorily advertised. My lord, in the present case, the procurement was not only satisfactorily advertised, in fact, the last date for submitting the bid was extended on 3 occasions, my lord. On 3 occasions, which...
So, condition 1 is not satisfied.
Condition 1 is satisfied.
Yes.
Secondly, the qualification criteria were not unduly restrictive. My lord, in this case, it is not unduly restrictive. It is to some extent flexible, and the bids have been received by the respondents. Thirdly, prices are reasonable in comparison to market values. Now, my lord, until and unless the respondents open my financial bid, they will not be aware of the quotation that has been quoted by me, and as such, condition C has not been complied with them.
Okay.
By them.
Yes.
So, my lord, in my humble submission, this impugned letter dated 1st May 2023, which is the last page of the writ petition.
Yes. Yes.
If your lordship kindly has the last page of the writ petition, page 577. My lord,
yes,
it simply says this has a reference to the tender submitted of the above subject. The management of MEPGCL decides to cancel the above tender. We appreciated your participation in the bidding process. Now, my lord, the technical bid was opened in the month of January 2023.
It was opened in
January, my lord.
May, when? Jan 23, okay.
Lord, it was opened in January 2023. Lord, they were well aware that only two bids have been submitted, and only one of them has technically qualified. It is not a case that they came to know about it in the month of May. From January till May, my lord.
So you're the only ones technically qualified?
Yes, my lord.
Yes.
As per the affidavit filed by the respondents.
Okay.
Now, my lord, on 13th of January 2023, they came to know about it. 13/1/2023.
Okay.
Lord, from 13/1/2023, I have been declared to be technically qualified and I am the only technically qualified bidder. So my lord, once I am the only technically qualified bidder, I will definitely be having a legitimate expectation that the award will be issued in my favor.
After you meet the financial parameters as well, yes.
My lord, financial, my lord, nobody else was there.
Even then, yes.
Legitimate expectation arises that I will be getting the award.
Yes.
That is why, my lord, for such a huge project, I had kept my entire team ready to complete the work within the time frame as per the contract which would be entered into in future. But my lord, from January till May, though the entire team was ready, everything had been kept in place so that there is no delay in the work. On 1st of May, the respondents come up with a letter that we are cancelling the tender process for no reason at all.
Okay.
And in the affidavit in opposition also, my
You
lord.
mean to say that they are bound by this directive of the World Bank?
Yes, my lord, they themselves have stated that.
They are bound by it.
They themselves have stated that, my lord, in the NIT. They have stated that it will be through national open competitive procurement using request for bids as specified in the World Bank's procurement regulations for IPF borrowers, November 2020 procurement regulations.
Yes.
So once, my lord, they are bound by the November 2020 procurement regulations,
Yes.
the cancellation of the tender is invalid. It is legally, it is absolutely illegal and violates the petitioner's right, my lord.
Yes.
A fundamental right to occupation, more specifically.
Fundamental occupation?
Yes, my lord, because we were depending on this. We had kept the entire team ready. There is no other reason in the affidavit in opposition because of which the tender process has been cancelled. This is the sole reason given in the affidavit in opposition.
That's it, that's no opposition?
My lord.
Where do they say that they are bound by that?
My lord, they do not make a whisper about the regulations.
They say they've admitted here.
Admitted in the NIT, my lord. The NIT is a binding document once it has been issued by the respondents. They cannot step back from that. Number of judgments have been quoted, though they are not applicable in the instant case, because the facts of this particular case is absolutely different from the judgments which have been quoted. And so far as
one thing, Ms. Arvadi, can you say that this court can sit and issue a mandamus that the contract be awarded to you?
my lord, I do not pray that the contract has to be awarded to me.
That is the consequential event that will happen.
No, my lord, but they are bound by clause number 5.59 subclause C, which says that the market value of the project, if it tallies with the amount quoted by me, then I am supposed to get the award. My lord, my only humble prayer is
now,
let them open the
how do you
financial
say
bit.
that the cancellation is vitiated? Is it done in public interest? The cancellation, they have to prove that. You see that now the parameters like in law has changed, with regard to, even because it's public largesse, number one, and number two is that equity and natural justice, like they're not applied like in a straitjacket formula. Regarding violation of rights and other regarding jurisdiction especially. You see the trend of later judgments, if you've been following, is that they give that's what they call it the fair play in the joints.
Yes.
The other judgment was that I've forgotten SS something. Anyway.
My lord, in this instant case,
yes,
the judgments would have applied if they were not following any other procurement regulations. In the instant case, the regulations are already in place, and the regulation they are bound by that particular regulation.
Where have they addressed that?
My lord, page number.
Where have they addressed that they're not bound? They're not bound by the directive of the World Bank.
My lord, they have nowhere.
In their case,
they have nowhere stated that. They have not made any whisper about the regulations in the entire affidavit in opposition. There is no whisper about it.
Yes, Mr. Sai, how do you address that only point? If you say that the tenders as per the prescription of the World Bank with regard to acceptance and cancellation,
Lordship, page 21 of my counter, point number D. Lordship, if I may say so, Lordship has hit the nail on the head. The only issue is whether or not the guidelines of the World Bank are legally enforceable by way of this writ proceeding. That is the only question. The World Bank grants financial assistance to certain projects on certain terms and conditions. These terms and conditions are neither statutory, these are neither guidelines, these are neither contractual. These are terms which have been agreed upon between the World Bank and the employer. These are not guidelines which in any case can be sought to be enforced at the instance of a tenderer in this case. That is my first argument. And Lordship will find that at page 21 of my counter affidavit, I have precisely for this reason, sorry, not page 21, where I've said no legal right. Page 17, para 14.
Yes.
Under the heading B, no legal right in favor of the petitioners. It is only submitted that the writ petition is liable to be dismissed, since the petitioners have failed to disclose the existence of an enforceable legal right in their favor. It is settled law that there must be judicially enforceable right as well as a legally protected right before one suffering a legal grievance can ask for a mandamus. A person can only be said to be aggrieved when a person is denied a legal right by someone who has a legal duty to do something or abstain from doing it. The only right in favor of a bidder is objective and impartial consideration of the bid. This has clearly been done. Therefore, beyond the right of consideration, the petitioner cannot sustain a writ. So, we have in express terms, Lordship denied the existence of a legal right altogether. And what my learned friend is pointing out are neither contractual nor statutory, and under any realm, Lordship, they cannot be enforced in a writ. At the highest, the remedy of the petitioner would be to file a civil suit and claim damages if it so finds. Even there, it will have to establish that these guidelines are in fact binding on us, and that non-following of these
no, the very fact that they have to establish that, the very fact that they have tendered and been found to be the only successful, I mean the eligible bidder, like those terms apply to you and be enforceable by private law. That is
Lordship. And only one other thing, Lordship, I'll just, because the law is quite clear, this is, Lordship has dealt with so many matters and in fact has restated it in so many matters. The requirement for me at this point is only to show 5 things. 1, that the decision making is not beyond the powers. I have not exceeded my powers. 2, I have not committed any error of law. 3, I have not breached any rule of natural justice. 4, I have not taken a decision which is contrary to Wednesbury reasonableness. And 5, I have not abused my powers. These are the broad contours on which some consideration may fall, because it is not the decision which is tested, it is the decision making process. And here, admittedly, there are only 2 bidders for a project which concerns dam rehabilitation and highly expertise laden field, a field that requires high expertise.
Okay, what is the project cost?
Lot of the project cost, in fact, because the financial bid was not open, we could not discover what the financial terms.
No, I mean as per your estimate, I mean they can quote above or below, whatever that financial bid is a different thing from what is the like value of the work.
That I have to just check, I'll point that out. But in the present case, of the 2 bidders, one was not even technically qualified. So the remaining bidder, which is the petitioner, is the only qualified bidder in this project. So it is like necessary, it is like putting the employer in a position where there is no choice to be exercised, and the tenderer must necessarily avoid the works.
No, that's out of the question. It's only that she's impugning the decision-making process.
So that is
saying that you're bound by this, which
And Lordship will come back to the guidelines. At 567, I will demonstrate that even the guidelines are followed. Even the guidelines are followed.
Lord, something cannot be demonstrated from just by verbal submissions. It has to come by way of affidavit.
Let him submit. 567.
Lordship.
Yes.
Yes, 566.
Yes.
Effective competition and lack and 5.59. I'm only on effective competition is lacking because that is the only provision that is invoked in the present case. 5.59. Lack of competition shall not be determined solely on the basis of number of bidders/proposers. Even when only one bid of proposal is submitted, the proposal may be considered valid if the procurement was satisfactorily advertised. I'm not disputing that. 2. The qualification criteria were not unduly restrictive. Lordship, this provision becomes activated in the present case. Since it's a dam rehabilitation project, Lordship will find that the eligibility criteria that have been set forth in the tender document are quite restrictive. They require a degree of expertise which is uncommon, which is not something within the competence of every other tenderer. So therefore, point number B, the qualification criteria were not unduly restrictive. This is not being met in the present case. These are restricted tender conditions. These are highly expertise-based tender conditions. C, prices are reasonable in comparison to market values. This, of course, does not come into play for the reason that the price bid was not opened in the present case. So therefore, I am saying that since the nature of the project, if it was something in the nature of a road construction contract, where there are many tenderers in the market, then there could be a question that the tender conditions are also not restricted.
Has been set out in affidavit.
No.
Why you not address this concern? Because this is the main plank of the entire petition.
I'll file a supplementary affidavit.
Otherwise, at this stage, I don't know. But then you've not whispered about this condition. I mean, like how they have not been, Because whatever it is, if there are guidelines also, there must be at least some functionary kind of.
My learned friend has just stated that this comes into force when the employer takes it. The employer out here is MEPGCL, and MEPGCL itself at page 16, the NIT.
See, read 5.59, MS Agarwal, is that, even when only one proposal is submitted, the proposal may be considered. It's not a question of shall.
It may be considered valid.
Like may be considered, They can have other considerations also.
But my lord, the ground on which they have rejected.
But you see, the other thing is that we have to balance it with your rights.
Yes,
okay, in the sense that what rights we acquired, or what vested right has been, or what civil consequences have been visited with.
And my prayer is not that, my lord, the award has to be given to me.
What's your prayer? Let's see.
My lord, my prayer was to set aside the letter, the impugned letter. My prayer was as to why the impugned letter should not be set aside and the tender process should be continued from the stage it was pending. Page 10.
You bring authorities, we'll have it again tomorrow.
My lord, tomorrow, my lord, it's Raksha Bandhan, my lord.
Oh yes, tomorrow. The thing is that, yes, you come with authorities because if you say that, how these guidelines, like what is the purport of the guidelines? If they come under a specific kind of project, if they have they're not just advisory, they're not really, what do you call it? Mandatory. You have to overcome it. And then the contractual matter, even natural justice sometimes doesn't come in.
Yes, my lord. Natural justice sometimes does not come in, provided the decision is taken in public interest.
And then there's a big, embargo now. Courts exercise self-restraint in interfering with natural matters because there's a judgment. It's not been cited by them, but there's a judgment I came across.
Yes. The court has gone so far as to say even if there is arbitrariness, then also your claim is only to file a civil suit.
Even if there's potential, even if the tenderer will suffer potential loss, the laws change so much now. Even there's a potential, there's an element of potential loss being caused to a tenderer who's been deprived of a certain work. due to the actions of the respondents. Even then, that also is not in writ jurisdiction. It's their judgments. You have a look.
Lordship, that judgment is UFlex versus National.
No, UFlex is one. UFlex is okay. There's another judgment which is. I've had my mind. I was just looking at it. Regarding fair play in the joints, with regard to the owners of the contract, where even like it may seem arbitrary, but if it's against public interest, if it offends the conscience, then yes.
My lord, it is I completely
Malafides. But have you alleged malafides here?
My lord,
You can only go if there's malafides, then maybe they've been intent to deprive you or something of the contract, that they would this malafide,
My lord.
You understand? You have not alleged malafides.
My lord, we have.
You have alleged malafides?
Yes, my lord.
By name?
Not by name, my lord.
Malafides one thing, to just say malafides one thing, but if you want to anyway, you come with authorities.
My lord, if it could be on 13th, my lord.
Okay, 13th. This is a matter of further hearing on 13th.
That's true.
Yes.